Please be seated. This is the time scheduled for oral argument in Robles versus State Farm. Each side's been allocated 20 minutes for oral argument. If the appellants would want to reserve any time for rebuttal, they can do so. There's a clock in the podium. It'll show you how much time you have left, including your rebuttal time. So if you want to reserve 5 minutes for rebuttal time and it shows 3 minutes left, you've only got 3 minutes of rebuttal time. You have to manage your own time.
Okay.
Okay.
Is that what you're saying? I'm on my own.
You're on your own.
But we're here with you.
Right.
Okay.
To advise you, you should both be aware that we have read the briefs, looked at the record, looked at the appropriate cases, and conferenced this case. So we're relatively familiar with the issues and the facts and the law. The fact that you've been allocated 20 minutes for oral argument doesn't mean you have to use it all. If you're done, you have anything else to say, we don't have any questions, feel free to sit down. Finally, you should be aware that we are both audio and video recording these proceedings. So when you, and actually I guess it shows up with a split screen, so the camera will show you and us when you're at the podium. So when you approach the podium, please clearly state your name, who you're representing, get ready for your close-up, and we'll proceed. So with that, counsel for the appellants.
Thank you. Kurt Hammond, appearing for Plaintiff Luz Robles, Your Honors. The gist of the case is whether or not State Farm acted unreasonably and whether they did it with a conscious disregard or a conscious and knowing unreasonableness. As you know from reading all the briefs, Jennifer Burns, the State Farm adjuster, reviewed an uninsured motorist claim, put a range of value on the case between $15,000 to $18,000. That range of value was created with no designated purpose other than that's what State Farm does, puts a range of value on it. Ultimately determined that $18,000 was the maximum, as I like to say, benefit that would be available to Ms. Robles for her uninsured motorist claim. But it was certainly the maximum amount that State Farm was willing to pay to meet their contractual obligation on the UM claim. Ms. Burns then began a negotiation process. Again, a process for which there was no designated purpose other than that's what we do. So Ms. Burns made an offer of $15,000 to Ms. Robles.
But I assume that in the negotiation process, it's not, it's, if Ms. Robles had come forward and said, listen, here's some things you didn't consider, it could have possibly even gone beyond $18,000, couldn't it have? I mean, that was sort of their range based on, State Farm's range based on what it knew at the time it developed the range. If Ms. Robles came forward with additional information, it could have gone up, well, even beyond the 18, possibly.
Well, it could have, but the concept is, at what point does Ms. Robles say, you've given me everything that you're willing to give me under my contract, and did you consider this, this, and this? Mm-hmm. The point isn't, could she have? The point is, does State Farm tell you what they're willing to pay and tell you why and explain it, and then say, Ms. Robles said, well, I either accept that or I don't, or did you consider this, or did you consider this, or do I have additional information that might change that?
So basically your position is that the insurer has the obligation to come forward and say, based on this information that you've provided us and this adjuster's report, we are not going to pay anything more than $18,000.
Based on the information we have today, correct. That's what we consider the benefit to be.
And then if you have anything further, if you don't want to accept that, and if you have any further information, please inform us.
Correct.
Okay.
So I guess then what, from your perspective, what State Farm should not have done is set a range. It
Correct.
should have just said, okay, 15, that's it.
In an ideal world, correct.
Yeah.
Or if,
so you're really saying that an insurance company can't, for its own purposes, say, you know, these type of injuries, they tend to seem to have a common similarity, and this is generally what we think is within the universe. And now, Ms. Robles, let's, if you would please, provide us some additional information. We can try and figure out where in the universe would be an amount. So that's what they shouldn't do.
No, what I'm saying is, if you do a range of value and your insured doesn't want to negotiate because the sole purpose of the negotiation is for you to accept an amount less than what they've already determined they're willing to pay.
No, that's not a range. I think that's where I'm having a struggle here. It's one thing for a person to say, okay, this event happened, here's my offer, and this is all I'm going to pay. We've been in negotiations. You've done that type of negotiation where you say to the other side, this is it, take it or leave it. It's another thing for me to, I think, say, okay, based on information I have, I'm thinking that this is a range. And where I fall within the range will depend on what information I'm provided. I don't see how that is bad faith.
Well, that's not this case, though. Ms. Burns determined a range based upon the information she had. She required no additional information to pay the 18 than she did the 15.
That's not what she said in her deposition. Pages 41 through 44 or thereabouts, she basically said she was expecting additional information from Ms. Robles, and she didn't get any. And when you look at the correspondence, the negotiations came to an abrupt halt. I think it was basically June or thereabouts, and no other information was given.
Well, I don't have her transcript in front of me, but I believe the information she was looking for was a counter offer.
Yes, with information to back up why additional amounts would be appropriate to pay out.
She didn't need additional information. She was authorized to settle the case at 18 from the first moment she had the file.
Mr. Hammond, I kind of think we're going around and around. The conceptual problem I'm having is it does not appear to me, based on Arizona case law, that it is improper for an insurer to set a tentative range based on preliminary information and to say to the insurer, basically, if you give us more information, we'll see if we can basically upward adjust. That doesn't seem improper, and I don't know of a case that says that's bad faith. Now, I'm aware of Zillich, but there's a whole boodle of other factors that were going on in Zillich.
But in this case, she increased her offer based only on a counteroffer. So the pretext that you need additional information isn't there. All she did was went from 15 to 16.5 based on a counteroffer.
Record reflects that she'd asked for information. You had some.
She didn't ask for him.
Well, excuse me, I've got the letters right in front of me,
okay,
and I can see what they say. And that there were some oral communications that are not necessarily memorialized in this record. But based on her testimony and the evidence, it appears she did get a little bit more information and thus upward adjusted based on information that was available. And that's when this case came to a halt.
She got a counter offer is the only additional information she got. And she went from 15 to 16.5 and said, I'm willing to negotiate more, I just need a counter offer. If that's the sole information you need to change your evaluation, that's a pretextual claim. It's not like you need additional information on the claim itself.
I have her May 17 letter in which she explains that she had reviewed the vehicle damages, noted the impact, noted the claim is primarily for the treatment of neck and back strain. Based on the current documentation, she says, you know, we just can't take your $40,000 counter. She raises the 16.5 probably in an effort to get it resolved. How is that bad faith?
If you're willing to pay your insured $18,000.
That's not what she's ever said. She had a range based on information available. That's what she says in her deposition.
And she said she's willing to pay 18. She could have paid 18 on the first offer, and she was required to negotiate, and she doesn't know why. That's bad faith.
It might be nice if she had given you a better answer as to why, but the facts speak for themselves, and the facts are she was basically saying, the witness, this is a line, I think it's page 42, if the insured has questions, provides any additional information, yes, there would be potential for the top value.
She also acknowledges that she could have offered 18 from the first moment that she had the file. and that she wanted to engage in negotiation because that's what they do. If you're an insured and you make a first-party claim, and your insurance company, whether they do a range of value or they don't, says we're willing to pay 15 to 18 to resolve your claim, knowing that they're willing to pay 18 now with no additional information to pay your claim, they offer you 15 and you accept it. Do you not feel as though you've been deprived of the full benefit of your contract?
I guess the problem is, and I don't want to beat the horse to death here, but you interpret a range as being they were locked in to offering 18. I look at a range and say it depends on the evidence as to where that number will be, especially in light of Voland that talks about the inherent uncertainties in determining what is an appropriate settlement amount for personal injuries.
Okay. In a general concept, that may be true. In this one, Ms. Burns didn't indicate that. Ms. Burns said at all times she had authority to resolve the case for 18 and could have offered the 18 as her first offer and elected not to by saying, I'm going to offer 15. The negotiation process, she doesn't really require any additional information. She requires counter offers. She requires negotiation. The negotiation, you cannot articulate any purpose that is beneficial to the insured by negotiating.
So your position, let me see if I can cut through this a little bit. Is a fair summary to say your position is that the insurer, State Farm, had a duty from the get-go to say, we are willing to pay up to $18,000. That's our maximum.
That's what we're willing to pay for your claim.
For up to that amount.
Up to that amount.
We're not making that offer now, but we are willing to pay up to that amount. But our only offer now is $15,000 or $16,500 or whatever it is.
Perhaps.
That would have been okay.
Well,
that would not have been bad faith.
Well, or at some point when your insured says, I don't want to negotiate, just tell me what you're willing to pay because this is delay. I want to get to your number so that I can make a decision whether I want to do the evaluation mechanism or accept your number rather than play this game where delay is important to the insured. It's not to the insurance company. If you say 15, your insured says, well, you have more. Yeah, just tell me what you're willing to pay. And if they refuse and say, well, we'll go to 16.5, we might pay more, you have to tell your insured because you're playing games with them.
And do you think the insured has a duty to say, tell me your maximum? Or should that just be, it's bad faith if the insurer doesn't just start off by saying our maximum is 18?
I don't know that they have to start off, but at some point they have to disclose to their insured the amount that they're willing to pay that they've determined on the file. And if your insured doesn't want to negotiate and sends you a letter that says, I don't think you're playing fair, just tell me, you got to tell them. And the failure to do so is a breach of the duty of good faith and fair dealing.
You know, I'm telling you, you make an interesting argument, but I go back to her deposition, and she says at page 42, we're seeking if the insured, we make an offer, and he says, well, that's not agreeable to me. I think that I have had greater pain and suffering, and I think my claim is worth X amount of dollars. We can say, oh, okay, yeah, we see your point. We would agree to move a little. Again, it is information that the insured provides that helps the adjuster have a better understanding of the nature of the injuries so that the adjuster can move within a estimate as to what the claim is worth. I mean, this is her testimony. This is the record before us.
And the record before you is she could have offered 18 on the very first offer. Based on the information she had, she thought the claim was worth 18.
She thought it was worth a range. That's what she testified to.
A range with a maximum value of 18. Based on that information. She needed no new information to go to the 18. You're saying that they have to give additional information to wheedle it out of them? That doesn't make sense. In other words, she already had the 18. She could have settled the case for 18. She didn't need additional information. It's the pretext of negotiation in the hope you'll settle it for less than 18. That's the problem. She didn't need the additional information to go to 18. She could have offered it from step one, but she said that's not what we do. That's not our process.
Though, her letters explained that based on the information provided, they made the initial 15. So I'm having a hard time squaring what you're arguing with the record in this case.
That's her testimony. Okay. If you read her testimony, she said she could offer 18. She could have settled the case day one for 18. Didn't have to offer the 15, except for it was State Farm policy to do so, but she could settle the case for 18.
But again, these are not, these types of claims are not exact science, where someone's coming in saying, okay, I've got medical, you were here for part of the last
Sure.
argument, I think. And, okay, here are my medical bills. My medical bills are $15,000 or my medical bills are $18,000. It's not an exact science. I mean, an insurance company can say, listen, we know from prior experience that these things have a range. Generally, they fall between 15 and 18. We think the maximum would be 18, but we're willing to offer 15 simply because, based on the information we have now, that seems to be the appropriate amount. That wouldn't be bad faith, would it?
If you disclose what you're willing to pay,
But you're saying you have to, at the same time, have to say, we're willing to pay 18. So let me go back. You're saying that it would not be bad faith if the insurance company said, we think this claim is only worth 15. If you can show us it's worth more than that, we're willing to pay up to 18, but that's it.
perhaps.
That
No.
might be bad faith, because remember what happens if you come forward and say, well, I can prove it's worth 50.
No, my ideal concept is you put one number on it. While it's not an exact science, of course not, but insurance companies do it for a living. Plaintiffs' attorneys do it for a living. In the first party arena, doing the range of value in the negotiation only results in delay. It only results in the process by which the insured is delayed to get to the valuation mechanism. Because ultimately the insurance company just wants to go back and forth, do counteroffers, back and forth, and eventually maybe you wheedle out their top number that they're willing to pay, that they've already determined they're willing to pay.
And your argument as a matter of law is that Zillage, that's your best case.
Correct.
Zillage says you should not be putting your insured through unnecessary hoops. And you're saying it's an unnecessary hoop if you're negotiating without disclosing what the maximum amount is.
By forcing your insured to negotiate to get to the number you're willing to pay.
Well, okay, not willing to pay, the most that you would pay. Not willing to pay, but most you would pay.
Well, in this case, it was the amount they were willing to pay.
Well,
She acknowledged it in her deposition from day one. She could have settled the case for $18,000.
but again, that's because we think it's maybe only worth 15, but we normally think that it could go up to 18. I mean,
That's not what she said. She had authority to settle the case for 18.
okay.
But
You're right. She had authority because the justices have a level of authority. She couldn't go above 25. So, again, yes, she was authorized to pay 18 because she had settlement authority. I think it was to 25. So,
no, she put a value of 18 and a number that she was willing to pay. It's the process. When you require your insured to go through that process in a first-party claim, what benefit is there to your insured other than delay or the hope that they'll settle for something less than what you've ultimately determined you're willing to pay?
what's your duty? What's the plaintiff's lawyer's duty? Here we have a demand, what was it initially, 45 or thereabouts?
Unfortunately, that wasn't me, but yes, those numbers
It
were
wasn't
me.
you, but I mean, it's Ms. Robles' lawyer, and I mean that sincerely. I don't like delay either. I mean, we have some strong case law in this state about bad faith, and it's been well established what we're looking for, and it's serious business. But when you have someone who says, "Oh, I have a $45,000 injury," and when push comes to shove at the end of the line, we see it's around 19. You're putting an awful lot of burden on the insurance carrier. What's the obligation of the plaintiff to be reasonable?
Well, I don't do that.
I'm sure you don't.
I request that you tell me what the full benefit is you're willing to pay, and you give me your best number. If I disagree and I can tell you why I think it's worth more, I'll give you my best number. And then if we don't agree, we're done. We go to the valuation mechanism. That's the ideal model, so that your insured doesn't have inherent delay, and you give it your best shot to get it resolved. If ultimately the insurance company's best number is good, the case will resolve. If it's close and I can give an articulate reason why I think it should be more, in my best offer, not a fluff number, then we're done. We either have settled the case or we move to the valuation mechanism with clean hands because we haven't engaged in this process of negotiation back and forth. Ultimately, the numbers that Ms. Burns got didn't do anything to dissuade her evaluation, didn't change her concept of what she was going to do. She was either going to work her way up to the 18 and settle it or not. The information that was provided to her was all meaningless because she was just looking for counters. Just say a counter. And if you settle before that, great. I've now, instead of paying 18, I pay 16.5. That's a detriment to the insured. State Farm cannot articulate one reason why that process is beneficial to the insured. Not one. It's all detrimental to the insured. And shouldn't the insured have the quickest, most promptest, swiftest way to resolve their claim? Here's my claim. Tell me what you think it's worth. A range is, they do that, why I don't know, because ultimately you're going to put a top number on it. And if you force the insured to do negotiation just to get to it, you've delayed the claim. And the hope is they'll settle for less than that number that you're ultimately willing to pay. But if you give that number in the beginning, your insured has a fair shot. Okay, that's reasonably close. I think I should get a little more. Here's why. State Farm says no. Okay, we go to the valuation mechanism. But we've taken months of the delay out. We've taken the frustration out for the insured. Why do I have to keep doing this game? I pay you premiums. I make a claim. Treat me fairly. If you think my claim is worth 18, don't offer me 15. Offer me 18. Let's be fair. Why are you trying to make me negotiate in the hopes that I'll settle for something less than the 18? Or we get to the 18, it's now I've wasted a month, 2 months, and I don't like the 18, and I have to go do the valuation mechanism. I've just wasted 2 months. When these people are hurt, they may be out of work, they have other issues that are more pressing to them, and State Farm delays the value to them. Time is money. They earn money on their reserves. So for State Farm, it's beneficial to negotiate. It isn't to the insured. That's the inherent flaw in the process. On a first party, they can negotiate all they want on third party claims. But on first parties, they need to treat them fairly. And if you're willing to pay 18, you should tell your insured that. Hey, we're willing to pay 18. We've looked at your case. This is what we think it's worth. If you have some reason that you think it's worth more, give it to us. And if you give it to them and they think it's worth more, great. If not, they say, nope, that doesn't help us. We're still at 18. Your insured goes, okay, let's go value it. Rather than play the game of 15, 16.5, 17, 17.5, ultimately they get to 18.
So the bottom line really is that an insurer should just pick a number and say, this is it. You come up with information, and maybe we'll move, maybe we won't, but this is the number. We don't set ranges. So setting a range is really a bad thing to do.
I did insurance work for 20 years. I worked for insurance companies on first-party claims. I said never put a range of value on a claim.
Well, maybe you need to do a lot more CLE speaking out on CLEs. That's clearly not how the system works.
But
your argument isn't they can't set a claim. They can set a range. They can set a range as long as they disclose what the maximum amount they're willing to pay without any further information from the client, from the insured.
correct.
Right?
At some point, you have to disclose to your insured the maximum amount. You can't shortchange them. And that's what the process is designed to do. I mean, yeah, maybe it's contrary to what everyone thinks the general process should be, but I'm saying on a first-party claim representing first-party claimants, it's frustrating to them, and it's silly that they have to engage in that process when the carrier knows what a number they're willing to pay. And they have it in hand and say, we're going to tell you, but only after we engage in this meaningless back and forth, back and forth. And if you stop short, good for us. But if you get there, well, now you can invoke the mechanism, but now it's 2 months later.
Thank you, counsel.
Thank you.
We're out of time. I appreciate your argument. Counsel for the appellee.
Good morning. I'm David Bell. I represent State Farm Mutual Insurance Company in this matter. May it please the court. Having gone through plaintiff's opening brief and reply brief, I see, and I'd like to address what I see are two separate arguments in this appeal. In the opening brief, plaintiff is essentially arguing a very legal argument that I think the court has spent a considerable time on this morning, which is, as a matter of law, it's bad faith not to offer that top dollar at the range of value. In the reply brief, the plaintiff backs off of that and says, insofar as State Farm has pointed to Milhone and Voland and Lopez and, of course, Zewich, I think is the name of how I pronounce it, the Pennsylvania case, that what State Farm did here is different than what was approved in those cases from the standpoint of having, you know, I think the reasons discussed in those cases as having for a range of value, and what State Farm did here is different. And I think both, I intend to address both. As to the first point, this, it's as a matter of law, State Farm should have offered the $18,000. It's, as I think the court is well aware, contrary to Milhone, contrary to Voland, contrary to Lopez, where in each of those cases the courts noted and discussed that there was negotiation within a range, there was disagreement, and so that invoked the resolution process. I think in all those cases it was arbitration. The State Farm policy is here different. It invoked, in our case, a lawsuit, which ultimately, although triggered then the court procedure of arbitration to resolve the underlying UIM claim.
Well, although you can negotiate, but at least the claim, it's the waste of time, if in fact you know what the number is, and all you're saying is 40, 16.5, 39.5, 17, and so isn't, as I understand what Mr. Hammond was saying, it's the delay that creates a problem when an injured party and your insured needs that.
I disagree with his on that point in three respects. One, that that leads to the delay in comparison to what he's proposing. Two, that it's done solely for the reason to get the insured to accept less than the top dollar. And third, that it's sort of senseless. So first, it's solely for the reason to get the insured to accept something less than the top dollar. That defies common sense. That defies our experience of all of us as attorneys who negotiate claims, or in other contexts, negotiation. Why? Because people commonly look at a situation where there's going to have to be uncertainty in coming to a value. And they commonly, I would submit, look at it from the standpoint of, if I want to get to $10, if I want to get them up to $10 or down to $10, I've got to start at a different number. Because if I simply say, I'll offer you $10, then they'll come at a different number, and we're not going to end up there.
But Mr. Hammond makes a very good point. This is not garden variety commercial litigation. This is insurance. And Ms. Robles bought this policy to get security, to protect herself and her family, and she's been injured. And so she wants the insurance carrier to step up and do the right thing and do it promptly and not monkey around.
Be a good neighbor.
And be a good, thank you, and be a good neighbor.
Okay.
And so maybe in the common everyday world of commercial litigation, that was appropriate conduct. This is a different situation. He makes a very powerful argument. I pressed him on it, and he makes a very good argument.
And I would submit that that's not merely true in commercial litigation, that people experience that. I think people experience that in everyday life. I mean, think about the two biggest commercial, personal purchases everybody makes in their life, or a vast majority, are a home and a car. And in both of those circumstances, people encounter negotiation.
Let's talk
it is a
about this
personal
case,
thing.
though. Let's talk about this case.
Are you saying an insurance company's relationship to its insured is the same as a car dealer's relationship to a
No,
customer?
I'm not trying to say that. I'm certainly not trying to say that.
Okay.
But what I'm trying to say is that it is not unusual, it is not unreasonable that in an area such as a personal injury claim where there is uncertainty, where the insurance company is acknowledging, as Ms. Burns acknowledges at, let's say, page 31 of her deposition, that what this offer, the initial offer represents, is an estimate of what the claim can settle for. This is not simply this is not a range of simply what we will pay. This is, as discussed at page 31 of her deposition, this is an estimate of what the case can be settled for. And in that regard, it's not unreasonable for I would submit an adjuster to say, in order to bring someone into my range of 16 to 18, and which I think is a fair value, I should start at 15 or 16 in order to, particularly where they're at 40, 45, to see if they'll come down and engage in discussion and get information. Basically what he's saying is, in terms of resolving disputed claims or trying to resolve a questionable amount without invoking the resolution procedure of the policy, arbitration, litigation, whatever, that an insurance company can't do what our courts have done within the litigation context by saying, okay, you need to go to our settlement conferences and mediation now to negotiate before you have a trial. And in the sense that, what is the benefit of negotiation beyond just reaching a number? It invests people in the number that's reached if they can get there. There is the exchange of information. There is the potential exchange of minds. The negotiation process doesn't merely delay and is not directed simply at getting that insured to take less than that $18,000.
But that's why I harken back to, if the insurance company says, we have a range of 15 to 18 that we're willing to pay right now, but we're not offering you 18. We're offering you 15. Come forward with more information to see if you can get us up to 18. See if you can convince us that we should go to 18. That's all I think he's saying. Disclose at some point in the process what the top dollar is, even if you're not offering it. So I know whether that's, that if the insured says, gee, I have really solid case on 40, I'm not going to, it doesn't pay to negotiate anymore. Let's just go to evaluation.
How is that any different than in the real world than saying, we'll pay you $18,000, and if you're not willing to take the $18,000, what?
Because you didn't offer it.
All right, but essentially we're telling you at some point in time that's going to be on the table. Right. And you have to go through this process of convincing us we have to put that number on the table as opposed to another, and it's necessarily information based. And what I'm saying as a matter of real world and how negotiation occurs in the real world, yes, that number can be reached by additional information. But that number can also be reached by the exchange process of people exchanging numbers and expressing a willingness to change notions, change valuations. And in this context, it's not per se bad faith to do that, particularly with as Voland and Milhone really point out, these are it's an uncertain process of evaluating a personal injury claim. And you're trying to, in a sense, convince somebody that our number is an accurate one, it fairly compensates you. And that's a discussion process in many instances. And not.
I can understand why if you say, okay, we think it's worth between 15 and 18, and you disclose that, but we're not offering you 18. The party may just come back and say, fine, if you don't want to go to litigation on this, I'll accept 18. And that's your choice.
Okay. Well, essentially, that strikes me as to say, we'll pay you 18, and if you don't want 18, we're into the resolution process, or you've got to convince us something different. I would submit is going to increase the number of claims that go into arbitration or litigation, increase the number of instances where people are alleged bad faith.
It might, but it might also mean that at least both sides are coming into the negotiation process knowing that, is it going to be worth negotiating this, or should we immediately go to valuation, or am I going to be satisfied as an insured with 18?
Okay,
but even though it's not offered yet.
Right, and I can think of it. I simply cannot conceive of an attorney or an insured in that instance that is going to be bantering back and forth to get to 18 if they know, yes, we're not offering, if the position is, I'm not offering 18, 50, but I evaluate this as 18, but I'm putting 15 on it right now. And in essence, I think they'd be coming back and saying, hold it. Now that you've told me that you would offer me 18 and you're offering me 15, it's bad faith to be offering me the 15. I mean, it's another version of the argument, gee, you should offer me 18 to begin with.
Let's talk about this case, though.
Okay.
To be fair to Mr. Hammond, and because he and I had a vigorous exchange, at page 34 of her deposition, she's asked, question, and I'm assuming once you determine a range of value, that at any time you could resolve the case within the range of value. Answer, correct, unless there's some other information that may alter or change that range of value. And here, settlement package is provided. There's no other information. And so isn't she, in fact, saying that based on that information, she could have gone right to 18? And she didn't do it because she was attempting to see if there was a lower amount. I mean, isn't that really what Mr. Hammond is saying, that in the facts of this case, based on the information provided, she could flat out pay out 18, and she should have done so.
Okay. Yes, that's what he's saying.
That is what he's saying, right.
That's what he's saying.
And that's what
I don't
she said.
disagree. I don't
Okay.
disagree that based on her testimony, she said, yeah, she could have moved to 18, but I think there's a missing qualifier there if that's going to resolve the case, or if that's going to be a response to their next move, if it's going to help, in other words, if it's going to help settle the case, and just to, you know, the bold statement, it is somehow unreasonable not to move to 18 when the plaintiff says, I don't like this process. I'm not going to give you any more information. I'm not going to counter to your 16.5. If you know, you need, if you're not going to increase your offer without any additional information, if you're, but particularly if I'm not going to counter, I'm simply going to go in and invoke the resolution process. That I submit under Voland and Milhone certainly does not breach the duty of good faith. A reasonable value has been determined. They don't question that. They're very clear saying that they don't question that State Farm came up with an unreasonable range. This is a reasonable range. They don't question, outside the context of not offering the 18, that the 15 offer or the 16.5 offer were unreasonable. They're unreasonable only because they weren't the 18. And so insofar as, unless you're going to say negotiation is per se wrong, then for the representative to, in Ms. Burns' position at that time, to say, all right, I've offered you 16.5, you're now saying to me, you're not going to move, you're not going to offer any additional information, but most importantly, you're not going to move, then I'm not going to make an additional offer at this time.
Isn't your whole argument basically that she didn't want to bet against herself? Isn't that really what this comes down to?
I would disagree that it's purely not bidding against yourself, because there are certainly instances where once further down the road, someone can change their mind and say, okay, I want to take something else. I'm willing to change my mind and actually lower my demand. There are instances where this might be put into a settlement conference by a judge, at which point you have additional room to move without having to get additional authority or reevaluate the case. It's a matter of perhaps keeping something in reserve of what you've decided as your range of value to wait to see if they're going to change their mind and re-engage, as she says. So factually speaking, it still complies, I would submit, with Milhone and Voland from the standpoint of the insurance company is engaging the insured in trying to resolve the claim without without going to the litigation process. And insofar as they choose the litigation process or the arbitration process, as they talk about in both Lopez and Milhone, that's what the insured has decided to do. The insurance company hasn't required them to do that, hasn't forced them to do that. That's their choice in the circumstances, and so it's not the responsibility of the insurance company that they now invoke that as opposed to trying to negotiate the claim.
But we know that people buy insurance for reasons of protection. And I do understand your argument, but it seems like you're saying, well, we all know lawyers negotiate. We just know that's the way the system works. And even though Ms. Burns testified that based on the information, which apparently didn't change, she had determined 18 would be an appropriate amount to offer. You've just acknowledged that. She can nevertheless go under that to see if she can maybe shave off some dollars and save State Farm some money. In the context of insurance, there's something I think, and Mr. Hammond's made this point, unsettling about that.
Okay. And I don't think you have to jump to the conclusion that she's doing that to shave off some dollars, as to see if, by not responding at that time and waiting, to see if they will in fact come to a number that, let's say at some point, rather than actually filing suit, they decide now to drop their demand to 25 or 20, or to avoid the litigation, we're going to drop the demand. At that point, she puts 18 on the table. Now, she's not shaving anything, but what she's trying to accomplish is bringing them to a closer amount. Also, as she acknowledges on page 34, if that's not such, that 18 is not set in concrete either. That if they do provide additional information, she can change that number.
So your point is that
You go up as high as
she was
25.
trying to get the plaintiff, Ms. Robles here, to come closer down to where she could then offer up the 18.
And get it resolved without the process. That I submit is a fair, still fair within the context, and certainly not contradicted by her testimony. I think so. I think we've now covered the 2 points. I think in the responses and the questions.
Could we then talk about attorney's fees?
Technically, we never got to it in the opening argument.
Well, that's true, but
Okay.
And could we address it?
Sure.
We have a right to do that.
Ms. Robles submitted an affidavit that laid out the facts surrounding her financial wherewithal. And one of the issues under 12341 is whether the fee award will cause an extreme hardship to the party required to pay. And based on that information, it seemed to me that there's certainly a prima facie showing of extreme hardship. Now, I understand there wasn't an affidavit from Mr. Robles, but that's something that State Farm could have inquired about. So on this record, I guess what I'm concerned about is whether the court took into account the appropriate factors under Warner, and especially extreme hardship.
We did not have an oral argument of the application. We had the award, and the award was, silent on how the court determined those issues. I guess what the approach that this course has to take is there no reasonable way a court could look at what was before the court at that time and make a decision that, in the context of all the factors, even though that affidavit demonstrated that there was going to be hardship for her, even if it made that decision, without additional information from Mr. Robles, who was jointly and severally liable for the award, the plaintiff hadn't adequately demonstrated that it was going to be a undue hardship for the parties, for both plaintiffs. And it could also put that in, but then it also weighs that in relationship to the reasonableness of the claim, the reasonableness of the legal argument, whether it was well-founded in law. Something I plan to point out that I wanted to make clear is that I think the trial judge, we certainly put it in the application. This award is based solely on the time we spent after the arbitration award was entered. It had nothing to do with the prior litigation. And so the court was looking at an awarding purely for the litigation of the breach of contract and bad faith claims. So I would submit that based on what under the Warner case, what was submitted by the plaintiff in terms of the affidavit, but put that in the context of no affidavit from Mr. Robles and the other factors under Warner, the court did and could be seen as reasonably deciding that the $47,000 is an appropriate award of fees. Thank you.
Okay, thank you. Why don't you put a minute on the clock for Mr. Hammond to address the fees issue, since you didn't raise it in the opening and before we let you have a chance to shot at that.
I'm a little puzzled because while it's not clear in the record, Mr. Bell is well aware that Mr. Robles divorced Ms. Robles, was nowhere to be found, and that we were in the process of doing a stipulation to dismiss him when all this fell out, and we never got to that.
And there is some evidence in the record, isn't there, that she was the sole caretaker
she pays for everything. She takes care of everything.
Yeah.
So Mr. Robles is nowhere to be found. Mr. Bell knows that. It's a bit disingenuous to say, gee, he could have money when we were prepared to dismiss him out of the case. That's my response on Mr. Robles. Ms. Robles doesn't have a great amount of money. She felt, as you probably heard from my arguments, a bit frustrated and betrayed by State Farm, so she brought the claim. She shouldn't be dissuaded, nor should any other insured be dissuaded from contesting what they think is an unfair process. So it's not a meritless claim.
So what do we do? Do we remand it for further findings? Do we remand it?
Well, since there's nothing in the record, that's an interesting question. And you could just say it was an abusive process based on the record that you have in front of you today, that it's not a sufficient basis to award fees. She's clearly a pauper, or it would be financially detrimental to her without any clear findings in the record. So that's what I would request.
Okay. Well, thank both counsel for your arguments. We will take this matter under advisement, issue a written decision in due course. We will take a brief recess to allow the attorneys on the third oral argument to come forward.